process for government departments as well as various levels of government. It's not fair on the other stakeholders. Thank you very much, but the presentation is noted as is. We now go to the African Procurement Law Unit. Is it here physical or virtual? Physical, online. Okay.
Thank you very much.
Online. Can you hear us?
I can hear you, Chairperson.
Thank you. You can go ahead. You have 10 minutes.
Thank you very much, Chairperson. I'll appreciate it if the Secretariat can just share our slides with you. So in the meantime, I will start to just very briefly introduce the African Procurement Law Unit. We are a multi-institutional research unit focusing on the study of public procurement law from an African perspective. We've got researchers from 10 different universities across Africa and beyond, as well as a number of researchers in other public and private institutions currently actively affiliated with APLU and our projects. If you can see the screen, then you will see some of our lead researchers that's currently working on projects for us. So our input on the bill is not only informed by our own research expertise, including the insights of our foreign colleagues that have gone through similar law reform in the recent past, such as, for example, Namibia, Botswana, and Zimbabwe, but also by two major national workshops that we convened in February and July this year, where more than 120 stakeholders from the South African public procurement community, SM officials, other public officials, supply organizations, academics, NGOs, and practicing lawyers got together to discuss in detail what an ideal future procurement system in South Africa would look like. And those discussions have also informed our comments and input. We want to structure our presentation around two main focus areas. Firstly, the key objectives of the bill, and secondly, a few comments on the text of the bill. As a point of departure, Chair, we greatly welcome this bill. Over many years, we have called for law reform, including consolidation of South African public procurement law, and we've consistently worked towards that goal. We thus think that this bill is a tremendous step in the right direction. All that must now be done is some fine-tuning of the text in order to create the basis for an up-to-date and fit-for-purpose procurement system in South Africa. Turning then firstly to the key objectives that we want to talk to, and I've just got 3 points that I want to make here. Firstly, we consider one of the most important objectives of this bill to be the consolidation of public procurement law. It is now well documented and well known that we've got a highly fragmented regulatory regime governing public procurement in South Africa, which is one of our biggest challenges. To that effect, we think it is critically important that the committee considers bringing construction procurement fully in under this bill, rather than keeping it as a shared mandate between this particular area, which will be governed by the Public Procurement Office, and the Construction Industry Development Board. We therefore recommend that the bill deals exclusively also with construction procurement. Secondly, we think it is imperative that further secondary legal instruments beyond regulations, such as instructions, codes, etc., be limited as far as possible. It is also well documented that the large number of such instruments that's been issued over the last few years have caused significant disruption, uncertainty, and fragmentation in the public procurement system. We thus think it is really important that those be limited as far as possible. The second point around key objectives is the constitutional principles in Section 2171. We think that it is imperative that this piece of legislation, which really takes its cue from Section 217, should set out and flesh out the 5 key principles that our Constitution gives us around Section 2171. One of the most important things that this bill should thus do is to give content to Section 217, rather than attempting to define some parallel principles to Section 217. The third key objective point is the one around development. We think it is exceptionally important that this bill explicitly, clearly, and unequivocally give us the Section 2172 framework for the use of procurement in support of transformation in our country. This is a critical objective of this bill, and we cannot afford to have yet again another challenge to a regime set up. In addition to putting transformation as a key objective and stating very clearly how that is to be done, we think it's important that as a key objective, this bill also sets out efficiency and value for money as important objectives and give us the tools that we would need to effect that. Turning, Chair, then to the text of the bill and just a very few comments from us on the text. We have made detailed submissions, and we are sure that the committee will consider that in due course. Firstly, on Section 2, the objects clause of the bill, we think it is really important that that section be rephrased around the Section 217 principles. We believe that everything that's currently stated in that section can be accommodated under such a framework, but we think it is imperative that the Constitution be used as the point of departure and the structure for the objects of the bill. We think it is important to move away from a narrow public finance perspective, using Treasury norms and standards as the point of departure of the object. Public procurement is much more than just about money. It's about service delivery. It's about making government work. And to that extent, we think the object of this bill should take into account that much broader operational function of procurement than simply a public finance one. Framing the object of the Act thus through a narrow Treasury norms and standards lens, we think is a mistake. Secondly, we want to just make a few comments on sections 5, 6, 7, 8, 18, and 58 together. In this group of sections, we think it is really important that there be clarity on roles and responsibilities within the new procurement system. That is, who does what. At the moment, we think that the bill is not sufficiently clear between these sections about the division of roles and responsibilities, especially in the way that it uses the term procurement system. There is considerable overlap in the power granted under Section 8 and Section 18 regarding who will create this procurement system. And we think that will be a big mistake to continue with that uncertainty under a new bill. In our view, the bill should give discretion to institutions to pursue procurement with value for money within guardrails set by the law and through an emphasis on professionalization. We think also that the bill should give us a framework for core procurement methods in the Act itself, not in delegated instruments. Finally, Chair, turning to Section 17, which we consider to be probably the most important section in this Act, in this bill. We think it is imperative that this section gives us clarity and precision to avoid another challenge to a preferential procurement regime, which we can ill afford. To that effect, we recommend that clear authority be given to the Minister to prescribe the preferential procurement policy. If you look at the current wording of Section 17, it talks about implementation, it talks about application. It does not tell us who gets to decide the content of the procurement, the preferential procurement policy. We think that this will be a mistake to continue with this wording and will open the door to unnecessary litigation. We thus recommend to the committee that Section 17 clearly grants the Minister the power to determine, by way of regulation, the preferential procurement policy to be adopted, to be implemented, by all procuring institutions. Finally, institutions under Section 17 should only have implementation power so that we can have a coherent, centrally prescribed system of preferential procurement, which we think is the only way in which this critically important objective of not only this Act, but our entire procurement system will succeed. With that, Chair, thank you very much for the opportunity to make a few comments to the committee. Thank you.
Thank you so much. Right on time. Thanks for the presentation. Now we are with